3 criminals. They each knew their victim. They each shot their victim dead. 2 in the head, 1 in the face. All of them were arrested, and all of them were released. When people do the most, I do the analysis. Let's go. These 3 killers pled not guilty of the charges against them. Murder in the first degree. And what if I told you that there is an Illinois law that says it's okay to release them so they can fight their charges from home? Right now, there's a 32-year-old woman at the center of a controversial case, the case of the state of Illinois versus Quadajah Johnson. Johnson was told by the Illinois Appellate Court, 1st District, that she can be released with conditions while she prepares for her trial. But with a last-minute Hail Mary move, the state of Illinois said, not so fast. The state filed a motion to stay, which effectively paused the detention decision for inmate Cordasia Johnson. And what happens next could force the highest court in Illinois, the Illinois Supreme Court, to step in and define the limits of the entire system. And the system I'm referring to is the Illinois Pretrial Fairness Act, which is part of the state's Safety Act. The Quadajah Johnson case, this one case, could quietly decide how far the Illinois no cash bail law really goes. Now, before I get into the details of the other 2 killers, let me break this down simply. Illinois passed the Safety, Accountability, Fairness, and Equity Today Act, known as the Safety Act. They passed it in 2021, and it was enacted in 2023. It's a law that eliminated cash bail, and it changed how courts decide who stays in jail before trial and who gets to go home on pretrial release. The impetus behind this new law is the unfairness that existed between the haves and the have-nots. Some people who were charged with a crime but couldn't afford to bail out due to their financial status, they sat behind bars for months, sometimes years, waiting for their trial to take place. So this act was created to address those systemic inequalities in the justice system. In other words, it moved away from a wealth-based pretrial detention system. Let's hear what the governor of Illinois had to say about this act earlier this year.
The goal of the Safety Act, with its no cash bail provision, was to provide a better way to keep dangerous suspects in jail pending trial. At the same time, it was written to make sure people did not stay locked up for lesser offenses pretrial simply because they were poor and could not afford bail. Governor J.B. Pritzker today said it's been working.
The Safety Act has been highly effective. In fact, as you've seen since the Safety Act was passed, crime rates across the state of Illinois have gone down.
In November, when a suspect with 72 prior arrests, who was out on electronic monitoring, was caught on video setting a woman on fire on a CTA train, it reignited debate about the Safety Act. It prompted House Republicans to send a 7-page letter to Governor Pritzker with a series of proposals.
We drafted a letter to help him with those changes. Here are some ideas. You don't have to recreate the wheel. You can own it and you can do it because all we care about is the fix.
Among the suggestions, expand the offenses eligible for pretrial detention to include all felonies and allow for revocation of pretrial release if a person commits a new offense while on pretrial release.
But instead of money being the issue, the question now has become, is this person a real and present threat to a person or to the community? If the answer is yes, then they can be detained. But if not, they're supposed to be released.
So I think if they're really going to make the changes and amend the Safety Act to actually make it work, we have got to quit propping up criminals and repeat offenders and stand with victims.
Well, I don't know if anything needs to change at all, if anything. But let me say this. The Safety Act is working.
Nevertheless, House Speaker Emanuel Chris Welch expressed a willingness to listen.
In a role like this, you're always looking to see if you can do better.
All I've said is, and I think this is always true, I am open to listening to what changes ought to be made. These are tweaks that I believe that could be made to the Safety Act, but proposals have to be made in the General Assembly.
And the unofficial rule that Speaker Welch has imposed on the House is that before any bill can be brought to the floor for a vote, it has to have the support of 60 Democrats. That could make passing any changes really a challenge. We'll have to see what happens.
It's pretty simple in theory, right? But in reality, it's anything but. The law has created real tension, not just politically, but inside courtrooms. Because to enforce this law, judges are more limited. A judge can't just rely on instincts anymore. These cases have to fit into very specific legal criteria. And if the state doesn't meet that burden, the defendant walks. It's a gray area problem that many critics of this new law point to, and that is what happens when someone doesn't quite meet the legal definition of a threat, but still raises a serious concern. That space in between, that gray area, is where people say the system struggles.
We're behind bars where he belonged. We have to change the law.
The Illinois Network for Pretrial Justice defended the Safety Act, saying no pretrial system can prevent every tragedy, but the right tools are in place, saying in a statement, quote, "What is clear from publicly available information is that there was absolutely nothing in the law that prohibited the detention of Alphonso Talley while he was awaiting trial. Any statement to the contrary is manifestly false." A former Cook County State's attorney disagrees.
Enough is enough. This has to end. Now we have a dead police officer, Bartholomew, and another one clinging to life. How many more examples do we have to give? And I can give you dozens more. We don't have time, but I could, of terrible judgment by judges in this county.
Even now, there's disagreement about how this law should be applied. Different courts, different interpretations, different outcomes. And when those things start happening is when the higher courts step in. And I'm not just speaking theoretically. There are real cases that critics point to when raising these type of concerns. Take the case of Alphonso Talley. Here are facts that were known about his crime before he was placed on pretrial release.
Today was the detention hearing for Alphonso Talley. That's the man who's accused of shooting and killing Chicago police officer John Bartholomew and critically injuring his partner. Talley sat smirking, even giggling at times as the state laid out their lengthy case against him. Prosecutors say that on Saturday morning, Alphonso and a co-conspirator were robbing a Family Dollar. They say they pistol-whipped a 55-year-old woman who was working there as a cashier and stole her wallet and $110 before fleeing on a lime scooter. Somehow, the money that was stolen had some sort of GPS tracking associated with it, and that led police directly to Talley. When he was arrested, he was not wearing the ankle monitor he was supposed to be wearing.
So for the powers that be who believe that electronic monitoring is a release condition that mitigates the safety risk, think again. Let's continue.
The monitor that he was already pinged for not having charged, he had missed curfew multiple times and had also missed a court appearance back in March, weeks before this shooting happened. When he was taken into custody, he had alleged that he ingested bags of drugs, something that he had already done according to court documents when he was accused of a different previous crime. Officer Bartholomew and his partner brought Talley to Swedish Hospital where he was about to undergo a CT scan, and when he was doing that scan, he had taken off his handcuffs and was given a hospital gown and a blanket. When they were in the CT room, prosecutors say that Talley took a gun, the same gun that was used during the armed robbery, out from underneath the gown and the blanket and shot Officer Bartholomew once in the head, killing him, and also shot his partner before fleeing the hospital, where he was later found and arrested 0.3 miles away. This has raised serious questions about the county's electronic monitoring program. Today, though, Talley was ordered detained.
Critics are now using his situation to argue that the law can allow individuals to still end up back in the community, even though they raise serious safety concerns. And it's not because a single judge wanted to release them, but because the law didn't allow detention under its current and strict criteria.
His release in that case has renewed calls for changes to the Safety Act. He was released despite the state fighting to keep him in jail. 6-year-old Alphonso Talley had a long criminal record that dates back to 2017, including a 2025 carjacking and robbery that he was originally detained for, but after a couple of months, Judge John Like released him on electronic monitoring. According to transcripts of the hearing first published by CWB Chicago, Judge Like said he'd seen growth in Talley and also said, quote, over the state's rigorous objection, the defendant's motion is granted.
This is a consequence of a failed system.
According to the transcripts, prosecutors outlined his criminal history, including armed robbery while wearing an ankle monitor. Not long after his release, his ankle monitor stopped transmitting.
5 weeks, this kid was wandering the street. Who's looking for him? Find that out. He was on probation. Heads should need to be rolling for this. There's no accountability.
Then there's John Perteet, another case that's been cited in similar conversations. 38-year-old John Perteet was arrested and charged with luring another man, 43-year-old Prince Johnson, into a deadly ambush on a far south side parking lot while wearing an ankle monitor for a previous felony gun case. Court records show that Perteet violated the terms of his nighttime curfew dozens of times, but a judge kept him on electronic monitoring anyway. John Perteet was the 12th person accused of killing or trying to kill someone in Chicago in 2025 while out on pretrial release. Those cases involved 25 victims, and 5 of them died from the assault. And again, the argument isn't necessarily that the law failed outright. It's that the law may not always account for patterns of behavior or evolving risk, at least not in a way that allows courts to act early. And that's the key point here. These cases provide great examples of substantial flaws in the Safety Act, yet they don't automatically prove that the law is broken. But examined together, they form a pattern that critics are saying that it's worth paying attention to. And with the right set of eyes from a higher authority, this law can be transformed into something that can truly protect the community from these violent offenders. Yeah, the acronym is clever, but the system itself is trash. Now let's bring that pattern into one case that's happening right now. We're going to circle back to the case of the state of Illinois versus Quadajah Johnson. Let's listen to what the Chicago Police Department learned on September 8th last year before releasing Quadajah Johnson with no charges at all.
But Romika Blackman, she just said goodbye to her 6-year-old son. She gave him a kiss and told him to have a great day in first grade. Moments later, she was shot 3 times. One of those bullets hit her in the face. Blackman worked 2 jobs and was in school to be an RN. Now her family is asking, why is the woman who pulled the trigger still free?
Well, she's not free now, Tia, but that status could change depending on a higher court decision. You see, what makes this case so important is that a trial court says she should be detained. The defense appealed that decision, and the appellate court said she should be released with conditions. Now, mind you, we're talking about the same law, but different conclusions. So for all the naysayers who say Holly is different, she's not some cold-blooded killer, it was self-defense. I'm asking you to think about this. If Quadajah Johnson can make multiple attempts to obtain an order of protection against someone she deemed to be her stalker and a threat, even though she had never met the person face to face. And after receiving the protection order, by default, let's not forget that, she failed to follow the conditions communicated to her by a judge for reporting the violation of a protection order made by her alleged stalker, Romika Blackman, the one she had the protection order against. I'm talking about something as simple as calling 911 when she first realized that Romika was standing only a few feet in front of her. That's what she was instructed to do by the judge. Yes, it was her first time seeing Romika in person, but she quickly learned who Romika was when she saw her engaged in a verbal altercation and being restrained by Carlos Smith. Y'all want people to believe that someone who can't even follow conditions for a TPO will follow conditions for pretrial release? I'm going to need y'all to have several seats. Being a threat to society ain't just about committing a crime while out on pretrial release. It's also about the possibility of her fleeing. And she can travel by car to one of our neighboring states of Wisconsin or Indiana in less than an hour. And I believe that possibility has increased now that she's had a taste of life behind bars. At Cook County Jail, of all places. 6 counts of first-degree murder can put her away forever. And she knows that. So the state stepped in and filed a stay, which basically means pause everything, we're taking this further. And that tells you something big right there. This case is about more than just one person. Because now this case could land in front of the Illinois Supreme Court, and they don't take cases unless the law needs clarification, the courts are disagreeing, or if the impact goes beyond one single case. This situation checks every box. If the Supreme Court takes this case, they could decide how hard the bar really is to detain someone. They can decide how much discretion judges actually have, and whether this law leaves critical gaps that need to be bridged. So when you hear about this case, understand this. It's not just about Quadajah Johnson. It's about whether the Illinois pretrial system, as it stands today, is working the way it was intended to, or whether cases like Talley, Perteet, or the Quadajah Johnson case are signaling something much deeper that needs to be looked into further, and by a higher authority. And hear me when I say this conversation is just getting started. If you enjoyed this video, please give it a thumbs up and share it with someone who can use this message. Subscribe to the channel if you haven't already done so, and leave a comment down below letting me know your thoughts. Do you think the law is doing what it's supposed to do in terms of fairness for lawbreakers who are presumed innocent until proven guilty? Or are there gaps so wide that laws like the Illinois Safety Act need to be revisited, reassessed, or outright repealed? Meet me in the comments. We can continue the conversation there.